All right.
I got it.
Share it, and then we're going ahead and go. Let me share it real quick. Share Twitter. All right, guys. Thank you for coming back. We had a little technical difficulty. But trial has concluded early today. And again, I want to bring in my legal correspondent, Brittany Dobbins, and she's going to give a recap from a legal perspective. Hey, Brittany, come on over here. So, trial ended today. It was scheduled to go to 5 p.m., but some interesting things took place during the defense's case while they examined Tasha K. Can we talk about that?
Yeah, absolutely.
Hold on.
Oh, okay, talk up. Sorry, guys. We didn't actually get into any additional substance of the testimony today because there were some procedural issues that started to break down the flow of the trial when defense counsel tried to introduce a video that plaintiff's counsel objected to as being something that was excluded during what is called a pretrial conference, which is a conference that happens before the case begins to determine what the evidence will be. They started going back and forth talking about whether or not this video was related to a compilation that the court had instructed defense counsel to dissect and put as different exhibits on the exhibit list. The court gave the defense a lot of deference and basically was sorry, crying here. Basically,
don't cry. We did enough crying inside
right?
the courtroom.
I know, right? Well, the court, the judge gave a lot of deference and said, if you can tell me what exhibit number the compilation was and give me a good reason as to why it should come in, then he can rule on the objection. And it pretty much turned into a little bit of a circus. The judge at one point told defense counsel that that's not how the law works, because one of their grounds for trying to bring in the document or the video, was that it was part of an exhibit list that was exchanged at the last minute. Hold 1 second so you guys can hear.
We're going to hold off because someone has to fall too long.
It was part of an exhibit list that was exchanged by the parties at the last minute, and that the defense counsel didn't object to any of the documents that plaintiff's counsel had introduced. Therefore, i.e., the plaintiff's counsel shouldn't be objecting to what the defense is trying to introduce, to which the court was kind of annoyed, and the judge was just like, that's not how the law works. So just because they didn't do something or they didn't object to something doesn't mean that now that's the benefit that you get.
So let me understand this. The defense had an opportunity through pre-trial to go through all the evidence, and the judge ruled on the evidence, but during the examination of their client, they wanted to introduce video footage. But then when the lawyer for Cardi B objected, Sarah Mott objected, they had a sidebar. And when they came back to the bench, the judge excused the jury because the judge took umbrage at the fact that the lawyer did not thoroughly look at the video footage prior to entering into evidence. And this was something that should have been done. His co-counsel said, Your Honor, well, this actually was done, but she didn't have the opportunity to speak at that point. So he said, well, I'm not 100% certain. So, correct?
No, that's not exactly correct. They did have a sidebar, and that is typically, if you don't know what a sidebar is, that's where arguments over evidence are heard because it can't be heard in front of the jury. It was an issue that couldn't be determined on the sidebar, so the court did exclude the jury, and then started having speaking objections for the court. the issue was the fact that they could not identify where this was on prior exhibit lists. And then the court tried to give them, the judge has to be impartial. So the court tried to assist by saying, is there any other reason why we should bring this document in, to which there was no other argument. And the court itself was not confident that that the video that they were trying to show hadn't previously been excluded. And so the court doesn't want to cause a mistrial. The judge doesn't want to be reversed. And so the court broke early so that the parties could convene on what the evidence is and make a solid determination that it wasn't excluded at the pretrial conference.
And the judge essentially said to the defendant's attorney that it's unfair for the plaintiff to have to pretty much help you with your case.
Yes, exactly. It's not the plaintiff's job to make the defendant's case. And I guess during the sidebar, according to the judge, defense counsel was putting plaintiff's counsel on the spot and saying, well, what is in the video that's objectionable? And that's simply not their burden. It's the defense's case in chief. It's their case to put on. It's their burden, and it's their job to know their evidence. And it just didn't appear that they did today.
Oh, okay, so you're an attorney, and I know you don't like bashing attorneys, and that's not what you do. But what was your take on the ending exchange as it played out in the courtroom? Because, from my perspective, it didn't look too good for the defense. And you're an experienced attorney. What's the lesson there? As an attorney watching a trial like this, and what due difference would you have done?
Well, first off, yes, we don't badmouth other attorneys. Cases are complicated things, so we definitely won't be doing that today.
She won't do that.
No. And there are unexpected things that happen that sometimes you're not necessarily prepared for, so it doesn't necessarily speak to the expertise of those attorneys. However, it didn't look good to the judge. It wastes court time. The jury didn't hear what was going on, but what they do know is that there is an issue with the evidence. It was brought up on defense's case, and that it's taking a lot of time out of their schedule. They're going to have to be here longer because of it. And so, you never know what effect that's going to have on the jury, the decisions they make, how well they listen as the case continues. So, it's not good. But like I said before, and maybe something if you are just tuning in, but a case is like a story. You want it to go smoothly. You don't want there to be a lot of breaks or a lot of unnecessary interruptions, because the way the person hears it and receives it, if it's less interrupted, a lot of times you can get your point across clear.
And you alluded earlier to there could be a strategy to lead to a mistrial. Can we talk about that?
I think, it depends. I was not here for the beginning testimony of the plaintiff's case, but I do know that there was some pretty interesting or damning testimony by the defendant, which satisfied one of the elements of the case, and that she knowingly published false information about Cardi B. That alone is very problematic to defend the case. So there could be strategic ways to try to introduce evidence that the defense counsel knows might not need to be in the case. And I'm not suggesting this. This was a comment that was made by the judge. The judge was unsure if defense counsel cared that the video might not be admissible, because it would force the plaintiff to try to decide at that point what they want to do. Do they want to leave it in because there's this phrase that we have as lawyers, you can't unring the bell, you can't, once the jury hears it, they've heard it, it's part of their decision, or do they want a mistrial? So, and there is a question of strategically whether they were trying to force a mistrial.
Well, guys, there you have it. This trial is having more twists and turns than the 285 expressway, and I would just say that we are due back in court tomorrow. Well, the jury is due back in court tomorrow at noon. Hopefully, the plaintiff, the defense, and the plaintiff can get these technical things worked out. So when we get back to the get back to business, it would be no more interruptions, or at least minimal interruptions, because there were also objections that was made. I want to say we talked about that on the first part of the trial. There were some objections made to the defense, against the defense.
I mean, there were several objections throughout the case. In the beginning half of defense's case, there were relevancy objections, or not relevancy, I'm sorry, leading objections, where the court had to give an instruction to the jury on what that means and admonish defense counsel on not to suggest answers to the witness. Leading. Yeah, that's what leading questions are, when you suggest an answer in the question. So the court explained that to the jury and told them, and requested that counsel not do that anymore. So, but we didn't actually get into any more meat of the testimony, right, because of the evidentiary objections. So we'll see, the coming days if if counsel is capable of not leading the witness.
And from my reporting, we did hear a lot of that, not doing that anymore from the judge, and apparently they're still doing it. But in any event, Ms. Dobbins, I appreciate you taking the time, and I do have someone else over here, and I want to
Don't forget to follow me.
Don't forget to follow on all the socials.
Yes.
But I do have someone else who's been in the courtroom, and I want to bring them in.
Yeah, but it's bdobbins.esquire. See y'all later. Bye, Queen.
I want to introduce another person who has been in the courtroom, and this is Lily Young. Lily Young, how are you today?
Good. How about you?
Good. So you sat in the courtroom today.
Mm-hmm.
What is your take on how this trial is going?
The trial, for me, I see it actually going in Cardi's favor.
Can you elaborate why?
Because Tasha K's team is ill-prepared. They have not prepared her properly to be on the stand. And I'm not trying to bash her, but I'm stating facts and what my eyes saw and what other eyes have seen. She kept hitting the mic. She was very nervous. No one prepared her for this, you can tell. And if they have, then that's a problem.
That's a problem, because if this is the preparation that she underwent,
Mm-hmm.
then it didn't.
It's not good. It's not good representation, and it's hurting her. I feel like her team has failed her.
So this, we had a legal analysis, and we have someone that is an average citizen that has sat in this trial, and she's given her perspective based on being someone that is watching the trial without a legal mind, but a common sense mind. Can I just say that?
Yeah, you can say that. Yes.
So guys, this is not going good for the defendant. And again, I just say that you don't bring a knife to a gunfight, and I mean that in the figurative sense. I don't want no thing I'm imploring guns, because I've seen a lot of the gun situations throughout this saga, and not allegedly, but let's just keep it on the fact that this case is not going the way the defense expected, unless they got a surprise. We don't know. There may be some, maybe they can pull a rabbit out the hat, but as it stands now, they got a lot of cleaning up to do.
A lot of cleaning.
So, are you on social media? Can people follow you?
Yes, I am. They can follow me at Lily Young. That's at LILLIEYOUNG, all over social media.
Very good.
And you can also subscribe to my YouTube channel, The Red Lipstick Hustle Lily.
Do you have some of that product on your lips now?
I have Hustler. This is my lipstick, Red Lipstick Hustler, and this particular shade is Hustler.
Okay, all right. Okay, we're going to charge for that commercial later on. But guys, thank you very much. I appreciate you tuning in. Leave a comment on the page. And let us know what you think about the coverage as well as the trial based on everyone's reporting. 1 second, I have to get it out the camera here.
Okay.
Okay, thank you. Bye, man. Please, thank you. But thank you very much, guys, for tuning in. We'll bring more up to date on day 6 of the trial of Cardi B versus blogger Tasha K. I'm Dennis Bryan. I appreciate you tuning in. And listen, share the video if you care. Thank you. We're out. Well, I'm going to read a few questions. Hold on, real quick. I'm going to read a few questions. The judge did suggest that early on about a complaint to the bar, but that's another conversation for another day. Guys, give me a second. Oh, look at this. Look at this. Yeah, I'm not going to bash the attorneys either. I would just say that I've seen some really great lawyers litigating cases from civil to criminal. And I would just say that you get what you pay for. You get what you pay for. I'm Dennis Byrne. I appreciate you guys tuning in. We'll see you later. Peace.